Welcome to the conferencing center. At any time during this message, please enter your participant passcode followed by the pound sign. If you are the leader, please press the star key now. Your passcode has been confirmed. If you need technical assistance during your call, press star 0. After the tone, please state your name followed by the pound sign.
Michael Lear.
Thank you. There are 6 parties in conference, including you. Hi, good morning. This is Judge Markley. Before we go on the record, I'm going to take a quick roll call to see who's on the line and make sure we have everyone we are expecting. Do we have complainant Mr. Lear with us?
We do.
Good morning. Do
Morning.
we have counsel for the respondent, Mr. Pham?
Yes, we do, Your Honor.
Morning. We have a court reporter? Yes, Your Honor. Renee Carrasco? Morning. Morning. Is my attorney advisor, Ms. Westcott, on the line? Yes, Your Honor. Morning. Morning. And is there anyone else on the line that I did not just identify? Yes, Your Honor, Karen Charleston. Okay, let's do that again. Whoever started speaking first, you go first. Your Honor, Karen Charleston for the respondent as well. Thank you. And was there a second person? Yes, good morning, Your Honor. My name is Colleen DeRosa. I'm in-house counsel for GFL. Thank you. Good morning. Good morning. All right, we have both parties and a court reporter on the line, so we'll go on the record. On the record, Your Honor. This hearing is called to order. This is a motion hearing in the matter of Michael Lear, complainant, versus GFL Environmental, respondent, case number 2023 STA 00061. Case is pending before the Department of Labor, Office of Administrative Law Judges, on a matter arising under the Surface Transportation Assistance Act of 1982. This motion hearing is being held telephonically on April 30th, 2024. I am Administrative Law Judge Monica Markley, and this matter is assigned to me for hearing and decision. Before the court today is respondent's motion for discovery sanctions. Included within complainant's response to the motion is his request for reconsideration of my order denying his request to disqualify Mr. Pham as counsel for respondent. We will address those two motions today. Respondent has also filed a motion for summary decision, but complainant's time to respond expires on Friday, so that motion is not yet ripe and will not be part of this hearing today. Complainant, Mr. Lear, would you please enter your appearance on the record by stating your name?
My name is Michael Lear.
Thank you. Counsel for respondent, would you please enter your appearance on the record?
Yes, Your Honor. Lehan Pham, Lehoan, last name P-A-M, M as in Mary.
Thank you. And Mr. Pham, would you just quickly identify the co-counsel you have with you today?
Of course, Your Honor. Karen Charleston, C-H-A-R-L-S-O-N, and in-house counsel is Colleen DeRosa, the two L's, and her last name R-O-S-A.
Thank you. The first matter I'm going to address today is the request for reconsideration of my order denying complainant's motion to disqualify Mr. Pham as counsel for respondent. That motion is denied. First, it was not properly raised. There was no motion filed for reconsideration. Instead, the request was included within complainant's response to respondent's motion for discovery sanctions, which is not a proper method of moving for reconsideration of a separate order by raising it as a paragraph included within a response on a separate issue. The request is denied for that reason. The request is also denied because complainant has not met the standard for reconsideration. He has not established a change in law, newly discovered or previously unavailable evidence, or any clear error of law or manifest injustice to justify the extraordinary remedy of reconsideration. Finally, his arguments lack merit. By way of example, one of the points he raises to allege that Mr. Pham has been misrepresenting facts by saying that when Mr. Pham said that complainant worked for about a year, that wasn't right because the date, one of the dates that he worked fell about 2 weeks outside of a year's period. Obviously, by saying about a year and providing the month and year, that was an estimate. Alleging that as the sort of grievous misrepresentation of facts that would justify disqualification of counsel is frivolous. As another example, complainant alleges Pham is both a witness and a lawyer in the same proceeding, but the allegations that he's a witness are not based on him having actually witnessed any of the facts underlying the termination or complaints in this case, but rather just summaries of facts in his pleadings, which comes within a lawyer's job. Those are just two examples of several of the arguments complainant has made, but having reviewed all of complainant's arguments again, they are frivolous. Mr. Pham does not represent complainant. He represents the opposing party, respondent. His duties are to the respondent. He is not engaged in any misconduct, and the motion for consideration is denied. Next, we will address respondent's motion for discovery sanction. First, I will let the parties know that the motion for a remedy of dismissal is denied. The ARB has made clear that dismissal is an extreme remedy or a harsh remedy that should not be used when lesser remedies are available. And I find that on the facts here, lesser remedies are available, and dismissal is not warranted at this point. We will move into the merits of the motion and address the particular arguments and what remedies are needed. Respondent points to 5 items of discovery that were requested, encompassed within the order compelling production, and according to respondent have not been produced. So we will address them in turn. The first is the separated and native format of the audio recording. Complainant essentially argues that those recordings are encompassed within YouTube videos he's posted, so respondent can find them there if they want them, whereas respondent argues that those items were requested in discovery and need to be provided in their separated and native format and have not been. Mr. Pham, I'm going to turn to you first as the movant. Is it still the case that those audio recordings have not been provided to you in the format in which they were requested?
That remains, Your Honor. Mr. Lear has only directed us back to his links as his the recordings to us, and they have not been produced to us. Well, we have some recordings in native versions, Your Honor, but we don't have all the recordings in native versions. And then, as our reply brief makes clear, after it was after we filed our motion for Lear uploaded what appeared to be additional information to his YouTube. So now there's a question whether or not he put all of the relevant native versions of his of the relevant recordings.
Okay, let me follow up on what you said last. After you filed your reply brief, are you saying that he filed additional information that you had not heard of previously?
It was after we filed the initial motion for discovery sanctions. On page 4 of our reply brief, mentioned that we saw 2 videos he uploaded on April 7th of 2024 that were uploaded after we filed our initial motion for discovery sanctions. And that calls into question whether or not there are additional audio recordings that he has not produced to us.
So the audio recordings that were included in videos posted after your initial filing were audio recordings you had not previously heard or been aware that he had?
That's correct, Your Honor.
And what date were those posted?
I see an upload date of April 7, 2024 on the one titled 2022-764. And I see an April 7, 2024 upload date for 2022-517.
Okay, Mr. Lear, I'll turn to you now. Why have you not provided the recordings that were requested in discovery to the respondent in their separated and native format?
So I've actually produced the recordings multiple times. Just every time I produce them, there's always some kind of an issue, whether it be the volume or at least that's what's alleged anyway, is that they're hard to hear, or there's always just some kind of problem with it. Other than then edited out the silence, just the beginning and ends of the recording where there was nothing of substance. But so that's what has been uploaded, is the intact clip with all the just the useless audio. But other than that, I've produced the audio multiple times, including the ones that he's saying that were uploaded after the discovery sanctions. There were 2 videos that I noticed that I guess they didn't get selected when I selected all the files to upload. But I uploaded them, yes, immediately as soon as I recognized there was an error.
All right. So when you say you have produced them multiple times, how did you produce these videos these audios to them?
So I know they received 2 of the short clips through Ethics Point, and then they received I believe they received quite a bit of audio from the OSHA investigation, and then since discovery has started, now that the case is...
No, hold on, Mr. Lear. Your discovery obligations are for you to provide them with requested documents, items, and other discoverable pieces of information. Not to say you can get this from the OSHA investigation. My question to you is, how have you used to respondent the audio clips that are at issue?
Right.
Don't say they could have gotten it through the OSHA investigation. I want to know what you did in response to the discovery request. Answer those discovery requests.
So as soon as discovery began, the first upload was to Dropbox, where they could access it was the meat of the recordings, not the me walking, just footstep sounds. So the first was Dropbox. I uploaded them to a Dropbox. That's when there was opposing counsel was complaining about the volume. I believe there was an issue with the volume. So he asked me if I had some that were a version that was louder, which is what we discussed during the deposition, where that's where I was agreeing to try to see if there was better quality. It's not that I hadn't produced any of there were some that had not been produced. It was just it was more of an agreement to get better quality audio. And then let's see from there. And after that, there was the Google Drive for the better audio, for the better quality audio. To upload them to a Google Drive, and that's where the whole February 12th and all this controversy came from. So that's why I just decided, after 2 attempts of trying to get the audio in a good quality, I figured, well, if I upload them to YouTube, then I can listen to them myself from there, and that way I know that there's not an issue with hearing them, and you can add your own, or you can, it does an auto transcript for the closed captioning.
Okay, so you're saying that you first uploaded the audio to a Dropbox, were told that the volume was bad, and asked for a louder or clearer version, and you agreed to provide one. You then provided a louder version through a Google Drive, and then finally you uploaded the video or the audio to YouTube. When you uploaded them to YouTube, they weren't separated. It wasn't just the audio. It was part of videos you made that included commentary. Is that correct?
That is not correct. So, because YouTube does videos and not audio, I added some of the images that I was already going to present, but I didn't voice over or anything like that. The reason they were added, they were uploaded to YouTube was because opposing counsel insisted on having all the useless sounds, the useless recordings. He insisted that they be intact, so that's why it was uploaded to YouTube.
YouTube is not an appropriate way to provide discovery in a case, nor is embedding something in a video with commentary. Using the Dropbox and the Google Drive, etc., is fine, but telling someone you posted it to the internet and they can go look for it if they want is not responsive to a discovery request. When a discovery request is made, you have to give the item to that party, not tell them you can go find it, somewhere else. Now, if the parties have agreed on using, email or Dropbox or, there are delivery methods, but just posting something to the internet and saying go find it is not the same thing as using a delivery method. So I am concerned about your use of YouTube videos, even aside from the fact that your videos include commentary and other things that make the clips difficult for respondent to know what you have, what you provided, and to have to go searching for things versus you providing them. Discovery should be a straightforward process of each party providing the other with the requested items to prepare for trial. Don't do trial by surprise here. Side provides the other side with the requested items in a straightforward manner. Everyone prepares for the hearing. Everyone exchanges exhibit lists, witness lists before the hearing. And then at the hearing, the court will take your offers of exhibits, hear any objections, decide what will come into evidence, hear from witnesses, take testimony under oath, and then by that manner create the record upon which the case will be decided. This case has been unnecessarily complicated by trying to turn discovery into a sort of challenge or game when it should be just a straightforward exchange of items. The discovery period has closed, and at this point we're going to determine what was exchanged and what was not, what remedies may be needed for items that were not. Mr. Fromm, I'm going to come back to you now. Mr. Lear says he did provide the audios in a separated and native format, first through a Dropbox and then through a Google Drive. Can you address that response, please?
Yes, Your Honor. It is true that Mr. Lear did provide some versions and separated versions of his audio recordings. The concern from GFL is we don't know what we don't know, and we don't know what all else he has in separated format. And what we were trying to do before we got the court involved was just to work with Mr. Lear for him just to send me either via Titan file, Google Drive, whatever it is, the full list of the separated out and native versions of the recordings, which he appears to have. But instead of doing that in this format, he has chosen to go down this route, making it very difficult and pretty burdensome for GFL to figure out, has he in fact produced all of the at-issue audio recordings in the format. We have some in the format, but we don't know if we have all in the format.
Okay. Do you have your own file, a list of what you have in native format?
We can come up with that pretty quickly.
Stop.
Okay. Here's how we're going to address the audio files. Mr. Lear, today you are going to make a list of every audio file you have, and you're going to provide that list to Mr. Fromm so that he can see whether he has the separated native format of all of the ones that you have. Can you provide that list by noon tomorrow?
I can even upload. I can upload the audio files to. I'll make another folder.
No, Mr. Lear.
Mhm.
That's not what I said.
Okay.
The time to exchange the audio files has expired. They have been asking and asking. Right now, we're trying to figure out what you have provided and what you have not. On a list of every audio file that you have. And they're going to have a list of the separated native audio files they've received. And then we're going to compare the two. But we can't compare them without a list of what you have. That doesn't mean sending more files. That doesn't mean further complicating. It means making a written list of the files and filing that list with me with a service upon respondent. Then they will know whether they have copies of all of the files or not.
Yes, ma'am.
Can you make that list and provide it by noon tomorrow?
Yes, ma'am, I can.
Okay, this will be, again, a written list. That should take no more than 2 pages. I don't want vetted clips, links to YouTube videos, any of that. I want a straightforward written list of the files you have so that respondent can determine whether or not they received those items in discovery. Right now, there's a big question. They acknowledge, as you said, that some were provided. But there is a significant question whether they were all provided or not in the separated and native format. Resolve that question. Just going to resolve it. We're going to make a list of what you have. We're going to have respondent make a list of what they have. We're going to see if there are any differences. All right, Mr. Fong, tomorrow's Wednesday. I'm going to have you file a letter by noon on Thursday saying for each item on Mr. Lear's list whether you have that audio or not. So tomorrow we'll get Mr. Lear's list. Thursday I will get your list comparing, after having compared his list to your own, informing me of which ones you have and which ones you do not have. Hopefully it turns out you have them all, but first we need to figure that out.
Understood, Your Honor.
All right. Turn to the next item. The next item are the documents of claimants' withdrawals from the employee stock ownership plan and the 401k account. From your pleadings, it seems undisputed that no documents regarding the employee stock ownership plan have been provided in discovery. I think Mr. Lear made reference that he does not have those yet, or did not get them, or did not receive them, or whatever. But because he doesn't have them, he didn't provide them, which means those were not provided in discovery. Is that correct, Mr. Lear?
Yes, ma'am. I can't produce anything I don't have.
Okay. Well, I agree with that. However, you were given months to conduct discovery. It means you could have undertaken your efforts in time to obtain those documents and provide them. Since that was not done, it's undisputed that the documents are not provided in discovery.
If I may.
Yes.
So I've sent the paperwork off. I don't know the total value of the stock until they only do the calculations once a year at a certain time. They told me that it would be no later than June. But I guess they don't know the exact time that they're gonna know. So I've sent all the paperwork off. It's just a matter of them determining the final price and sending me that paperwork.
Okay. Well, the discovery period's closed. Hearing is going to go forward at the end of May, and these documents are not going to be available to be made into an exhibit because you did not timely seek them in discovery. Could have availed yourself of various discovery methods to get those. Could have relied on your own documents that you may have saved from whether you made these withdrawals. But in any event, you've produced no evidence to respondent regarding these withdrawals. Getting something in June is not going to help us for a hearing that's going to happen in May, and for a discovery period that closed a month ago, or over a month ago. I'm sorry, that may not have been over a month ago, but has closed now. So for our purposes today of looking into the discovery issue, where these documents were requested and have not been provided, there's no question that there's no evidence for that particular withdrawal. Turning to the 401k, provided an email confirmation that that's the only document you had, but employer requested that you go into your account and get the actual account information and not just the email. Did you go and get that information from your account?
Yes, the email is the only document that is. I mean, I didn't have the account. I honestly didn't even set up the account myself. GFL set it up for me. And my only interaction with it was the one-time withdrawal of the $1,700. Like that's my only interaction with it.
Here's the problem, Mr. Lear. I understand that this may not be something that you were logging into frequently or ever or whatever, but you brought this case, came to court, you said, I want to avail myself of these processes to resolve my claim, and we said, okay, commence discovery, follow these rules, and then when respondent said, get us this we would like this documentation, here's our formal discovery request for this documentation, you didn't say, I don't know how, or I need help. You said, you can go get it yourself. You set this up, you go find it. And that's not appropriate. That's not what discovery requires of you. You have discovery obligations when you bring a case. And if a party asks you for documents that are within your control, and this is your account, so it's indisputably within your control, you have an obligation to go get them. You can't just say, you can probably find this out too, so why don't you go do it on your own? And those are the kinds of arguments you've made here. Now today you're giving a much more straightforward answer than what you gave in your filings. But in your filings, it was a more confrontational, they can find it, they have access type of argument that suggests you weren't doing this as an obligation that you have as a party who brought a case into this tribunal. And it is an obligation you have, and it's concerning that you didn't take that obligation seriously and try to obtain these documents. So what I'm hearing from you is the only thing I had readily available, etc., is the email confirming my withdrawal, so that's what I gave them. But you did have the ability to request information from your own account with the statement and the other information that respondent was requesting. But you didn't do it. Now I'm going to turn to you, Mr. Pham. You have the email showing the withdrawal, have Mr. Lear's statement that that was a withdrawal of the full amount of the 401k. Mr. Lear, is that correct, that it was the full amount of the 401k?
That is correct, and if I may add a little bit to the end.
Sure.
So any money that would have went into that account, I was under the impression that that GFL would have a record of that because they would have been the only ones to deposit that. That's the only reason I was saying that that they would have access to that information.
Okay. It's still your duty and responsibility to obtain the documents that are requested in discovery. And while I don't even know if they can access your individual account, but in any event, it's not their obligation, it's yours. They requested a document that is discoverable, and you needed to treat your discovery obligation in a straightforward and serious manner And that's where my concern lies. But I'm going to go back to Mr. Fong. If we have the email of the amount, have Mr. Lear saying that's the full amount, is there anything else that would be gained from the document that he did not obtain to produce, Mr. Fong?
Well, this is actually the first time I'm hearing from Mr. Lear everything he stated. If we have the email, we have his representation. If Mr. Lear is essentially willing to stipulate that the maximum plausible recovery of the 401k withdrawal is the amount stated in the email, then I think GFL is okay with not getting the actual account statements themselves. That being said, Your Honor, GFL does not have access to his 401k account. That's something that he has access to. But for purposes of today, if Mr. Lear stipulates that the maximum amount in the 401k that he will see as plausible damages in this case, now stated in the email, then we're fine with not getting the account statement.
Okay. Then turning back to Mr. Lear, do you so stipulate that the amount of that was your full amount of your 401k and the maximum amount that you're seeking to recover?
It slightly over 1,700. Yes, that was the max amount.
Okay. And the number is somewhere. You know which page of your response that is listed on?
I do not.
Oh wait, I found it. It's 22. Page 22 has the inset of the email that shows a withdrawal of $1,756.64. And it's your stipulation today, Mr. Lear, that is the full amount of your 401k and full and exact amount you're seeking to recover?
From the Fidelity 401k, yes, ma'am.
Did you have any other 401k?
Just the ESOP, but we've already covered that.
Right, exactly. Okay, great. Okay, so I think that covers the 401k, Mr. Palm. As you said, for today's purposes, you would be okay with that stipulation, correct?
That's correct, Your Honor.
And because there has been no discovery provided regarding the employee stock ownership plan, no evidence regarding that will be admissible as not provided in discovery. Of course, at this point, Mr. Lear doesn't have that evidence anyway, and it doesn't sound like he would have it by trial in any event. But were something to come up, that would not be admissible because it was not provided in discovery. That takes care of item number 2. Item number 3, text messages regarding employment that claimant exchanged with his managers. Mr. Pham, do you want to tell us what you have and what's missing in that regard?
Well, it appears, based on Mr. Lear's briefing, that he claims that everything he produced on the G drive constitutes all the relevant text messages he has.
Mm-mm.
And if that's the case, we're willing to move on from the text message. But I'd like to hear it from Mr. Lear himself today that text messages uploaded to his G drive constitute the full universe of relevant text messages with his manager.
Right, Mr. Lear, then the question goes to you. Are the text messages uploaded on the G drive the full universe, that is everything you have of text messages between and among you and your managers?
So any the text messages that they did not already have before February 3rd they were included in the request for disqualification. They were the last, I think, 20 pages were, I think, all the remaining text messages that they did not already have. The ones that weren't directly involved with the retaliation.
Okay. So are you saying that the ones that you put on the G drive are not the full universe of text messages? And in fact, some were omitted there, but the omitted ones were then included as exhibits to your motion to disqualify?
So I'm not 100% sure what text messages he's referring to on the drive, because there's so much confusion around what was accessed and when. But I know that.
I'm not worried about what was accessed. I'm worried about what you produced to them. Did you produce through discovery and not through other filings, i.e. not the response or the attachments to your motion, but just as a discovery response given directly to respondent, did you give them through the D drive all of the text messages?
So I included those in the filing that I also gave them a copy of in response to the order, or complying with the order.
I don't know what you're saying. In response to what order?
So the order compelling me to provide the stuff like the rest of the text messages. When I responded to that order compelling me, I gave them a copy of that response.
So in response to the order compelling production, you gave them a copy of your response or a copy of your request for disqualification?
That had the the remaining text messages, yes.
Okay, so let me follow. Through your exchange of discovery on the G drive, you provided some, but not all, of the text messages. Is that true so far?
I provided all of what was the relevant text messages.
Okay, well, discovery doesn't have to be relevant. It only has to potentially lead to relevant evidence. In discovery, you provide what's requested, unless you seek and obtain a protective order. At trial, I determine what's relevant if there are relevant objections. But in discovery, you exchange documents. So let's go back to the question. The text messages that you put on the G drive were some, but not all, of the text messages you had from the managers. Is that correct?
So the original discovery request wasn't requesting all text messages from every manager. It only requested the text messages that were linked to the what I was alleging was involved in the retaliation or reporting the step.
Okay, let's go about this another way then. You're saying there were additional text messages that were discoverable that were not provided, so you included them in your request for disqualification. Is that correct?
No, what I'm saying is that the original discovery request did not ask for all text messages with all managers. That was agreed to during the deposition.
Okay. So at some point it was agreed that you would provide all of the text messages, correct?
At the deposition, correct? Yes.
Did you put them all on the G drive?
Once the depositions commenced, I did not do any more uploads to the G drive.
So no, you did not put them all on the G drive.
Correct. No.
And the ones that you did not put on the G drive put as support for your request for disqualification.
Yes, ma'am. I put the remaining and the ones that they already had.
Your contention is that between the text messages put on the G drive and the text messages included in your request for disqualification, if you add those two together, that's all the text messages you have.
Yes, but also, if you can default to just that response requesting disqualification, all of the text messages are in that response.
Okay. Before I turn to Mr. Fahm, I'm going to just let you know that like the YouTube videos, is not an appropriate way to respond to discovery. Putting things in support of a motion you filed to the court, not an appropriate way of filing a discovery response. If the opposing party requests particular items of discovery, you have to serve those items on the respondent. Not say, you go digging around long enough, you'll find them, as attachments to various, some are here and some are there and some are in this motion and some are in this response. That's not their job. That's your job. Goes back to what we talked about earlier. You have a duty and an obligation to serve discovery responses. You can't send them on a hunt or a game to try to find it in other places you might have put it. Even if it's accessible places like attachments in support of a motion to disqualify an attorney or the public internet. Have to serve discovery responses that provide the documents that were requested. So this is again a way in which you have complicated something that should have been simple and straightforward. You had the messages, should have just provided them to them in response as they requested. And as Mr. Fahm pointed out, your discovery response was due the very day you filed your motion to disqualify him. So you should have been putting those materials together and serving an appropriate discovery response. Here are the items you requested. You had all the items, were compiling them as exhibits to your motion, should have also compiled them as an appropriate discovery response and served them, comply with my order compelling production and your discovery obligations under the rules and regulations that apply here. We wouldn't be having this hearing if you had just provided the documents in a straightforward manner. You had them, they asked for them, they were entitled to them, you agreed to provide them, not that that's a necessary precursor because they were entitled. And then rather than simply give them to them, you've dispersed things all around and then argued, if they look enough, they can find everything in these various places. That's not their job. It's your duty. And that's why we're now all having to come together today to figure out what you've provided, what you haven't provided. And this should not have had to happen, something that should have been straightforward. Mr. Fahm. Mr. Lear can't stipulate, as you proposed, that everything was on the G drive, but can stipulate that everything is in his attachments to his request for disqualification, which builds on those things that had been previously put on the G drive and then supplements it with everything that he has. So knowing that everything is in those attachments, does that satisfy your request?
Your Honor, I just, the only thing is that I just want to make sure that when Mr. Lear talks about his motion to disqualify, I think he's talking about the 230 attachments that he filed with the court. And if that's the case, if those attachments coupled with the G drive together constitute the full set of text messages that we request in discovery, then GFL will deem this issue resolved as well. But we just want to hear from Mr. Lear that what was uploaded to the G drive plus what was attached as part of a 233-page attachment. If I hear from Mr. Lear that together constitutes a full set of text messages, GFL will consider this issue resolved.
Mr. Lear?
They're all in the response plus, and then the ones that have already been provided earlier in discovery were on the G drive. So yes, you have all of the text messages that I possess anyway. That I possess.
All right, I think that's your answer, Mr. Fahm. Are you satisfied?
We are satisfied, Your Honor.
Okay. As I'm hearing, Mr. Lear, the answer is everything is in the 233-page response. Some of it is also on the G drive. Is that correct, Mr. Lear? Am I properly summarizing you?
That's correct. That's correct.
Okay. All right, so text messages have been provided, not properly, but they have been provided, so that is resolved. All right, item number 4, all documents related to the job log complainant filled out with the Georgia Department of Labor. Mr. Lear, why did you not provide that to respondents?
Because I don't have access to it.
And why don't you have access to it? That's the one where you just need to recover your password and verify your identity to obtain it?
So when I filed for unemployment, the Department of Labor had another company called he's called Employ Georgia, or it was something along those lines. But it's not the same company anymore that it was when I applied. So it's not just a matter of logging into the Department of Labor's the Department of Labor's website. I'd have to, if I'm not mistaken, I'd have to go and do a whole nother account creation, but then it would be with a different company. So there's no guarantee that they would even have the previous company's information.
Okay, so since these items were requested in discovery as part of a court proceeding that you initiated, why didn't you just do that and get the document?
Because that wasn't what was stipulated as far as the agreement. It was very explicit terms of if I have access to or the terms that I have control or access to them, which I do not. And I'm honestly not sure that the Department of Labor would even
within your control.
I'm sorry, what was that?
They're certainly within your control. Your own documents stored with the Georgia Department of Labor.
Well, I mean, so I don't recall there being like sorry.
I'm going to take a moment to look through the filings for the information direct to this.
Your Honor, may I?
Hold on, I'm taking a moment to review the document. All right, yes, Mr. Fahm, go ahead.
Your Honor, I was going to direct the court to page 21 of 70 of this motion. That's where the Georgia Department of Labor screenshot is.
All right, Mr. Lear, the discovery request respondent made was for all documents that refer to or relate to any claim for unemployment benefits, which Lear sought after GFL terminated his employment. So your argument that this doesn't come in the scope of the request is unavailing. The job log from the Georgia Department of Labor where you filed for unemployment benefits would clearly be a document that refers to or relates to your claim for unemployment benefits. So it certainly was an item that was requested in discovery. Your next argument is that the item's not within your control because you would have to pass through this identity verification to log in and obtain it. And this is a site that's still operated by the Georgia DOL. The emblem is right there on the bottom left of the screenshot on page 21 of your filing. There's no reason you could not have logged in and obtained that document. So the document was requested. It was within your control. Did not take the ministerial steps needed to log in and obtain the document. And in doing so, you did not comply with your discovery obligations or the order compelling production of the document. So I do find a discovery violation with regard to the Georgia DOL job log.
Your Honor, if I may.
Yes?
With all due respect, I have to disagree with that summary. I attempted to log in. That's when it directed me to create a new account with a third party, not just the Department of Labor. And I don't recall. So whenever because you have to fill the job log out each week that you're on unemployment, and I don't recall there being like anywhere that I could access, like it's not like there wasn't a history box or anything like that for me to view past ones. There wouldn't be anything for me to print from the Department of Labor's website. And I'm not sure. I don't recall exactly.
How do you know that there was a?
I'm sorry?
My understanding is you did not fill out these steps to create the new account. So how do you know whether there would be a history box or a way to obtain the document if you didn't proceed through the creation of the account?
Look, because the creation of an account with a third party, that just seems like a little burdensome.
Okay. Well, I overrule your objection. I find it is not unduly burdensome. I find that it would have taken seconds, minutes of your time to complete the verification process and gain access to your account, and then you could have complied with your discovery obligation. Instead, you took this as the first door out, not view it as something you needed to do. As long as I can say I can't get to the documents, I don't have to provide them. That seems to be the approach you took. So when it asked you to verify your identity, it asked only for your social security number and a password. Said, well, that's too burdensome. I shouldn't have to do that. And you didn't. And that's your choice. But I overrule your argument that that's too burdensome. And I find that this remained within your control, that you could have obtained the documents available through that portal, that you chose not to create the account and therefore chose not to gain access to your documents, and therefore it is a discovery violation. I understand you disagree. I understand you think you shouldn't have had to make an account to get your documents. I find that you should have. I'm referring to page 21 of your filing where you have a screenshot that starts with security of your information. And it says, enter your information below to get started. Social security number, password, and then there's a CAPTCHA, I'm not a robot box. So I understand your argument that it was burdensome to have to do that. I do not agree with your argument. I find that it comes squarely within your discovery obligations, that you should have created the account and obtained your documents, and by choosing not to, you did not comply with the order compelling production. That's item 4. Item 5 is the executed authorizations for personnel records and tax returns. Mr. Pham, we'll start with you. Do you want to tell me a little bit more about the authorization?
Yeah, thank you, Your Honor. I mean, when it comes to the authorization tax returns, I mean, I think it goes squarely to TFL obtaining information through Lear's earning capacity and his damages. We requested that back in December of 2023, provided him blank forms for him to sign. We, to date, have not received execute authorizations for personnel records and tax returns, which are frankly pretty standard practice in these type of retaliation cases. I've seen instances, Your Honor, where plaintiffs do not sign the authorizations, but otherwise produce that information, such as like their attorney, for instance, will go get the personal record and go get the tax return. That hasn't happened here. So DFL is kind of stuck. We know what Mr. Lear has done to mitigate a lot of damages, what his earning capacity could be, but he hasn't given us the documents for us to do that analysis, making it very difficult for GFL to defend itself at trial. So it's either or, Your Honor. Mr. Lear should have just given us the executed authorizations or given us the records that we requested in discovery himself, and he failed at both.
All right, thank you. All right, Mr. Lear, your response.
Regarding the authorization forms, they were requested in GFL's original discovery request, to which I objected based on relevancy. I didn't understand the relevance of previous employers and personnel records. I didn't see the relevance in it having anything to do with the retaliation. Rather than filing and have the court compel me to or to overrule that objection, excuse me. Instead, there's this issue with the sliding, I guess, what do you call it? Earmarking it in, kind of sliding it into one of the court's orders. But I don't because so the authorization forms were being requested don't even so the last 2 years aren't in the request, which is what you would need to determine the mitigation of damages. It appears to me to be more of a kind of a fishing request, because what I made before, I don't, or where I worked and what I made before, I don't think has any bearing on the mitigation of damages moving forward.
Okay, the problem with that is that I ordered and compelled you to produce the requested documents. Didn't file anything saying I want a protective order. There's nothing that limits that. It clearly applied to the requested documents, which you've acknowledged these were requested. In your filing on the instant motion, Lear has already answered questions regarding his history. Lear, not being aware of the alleged duty to mitigate, asked opposing counsel to cite the statute that imposes such a duty. I mean, they had told you it was in relation to the duty to mitigate. It's written right here. You may not want them to have it, but they're entitled to the requested documents. Beyond that, I then compelled you to produce the requested documents. No arguments were made at that time that you shouldn't have to sign authorizations. You simply failed to produce them. And now here we are, less than a month until the hearing date, and these items were never produced, which are necessary for respondent to investigate your duty to mitigate, as they told you.
If I may.
Yes.
So in the request to compel me to produce outstanding discovery requests, there was a very clear numbered list, 1 through 11, and the authorizations were not contained in that list. It was vaguely mentioned, I think, in a footnote, and then post the order, because with all due respect, the order didn't specify authorizations. As far as I interpreted the order, it was referring to the numbered list that was being requested as far as being outstanding. And then the first email after the order was given, another numbered list was sent by opposing counsel to me with that had a 12th an additional outstanding discovery obligation, which appears to me to be like a way of maneuvering around dealing with the objection of the relevancy.
Okay, well, you didn't file any objections to relevance, Mr. Lear.
Well, because
I don't have any before me, and if you had timely filed an objection, I would have timely ruled, and this would have been resolved during the discovery period, but you didn't file any objections. They served you with a discovery request for the authorization. You may have argued with them about it, but you did not file objections with this tribunal, and you did not seek a ruling or a protective order that would say that you don't have to provide requested items of discovery. And they have been asking you and following up with you repeatedly, and now discovery is closed and the hearing is imminent, and respondent has been unable to obtain what Mr. Baum correctly described as routine information. These are routine requests about your duty to mitigate your damages, which is relevant to your damages claim. You may decide you don't think that's relevant, but that's not up to you. If you had an objection and wanted a ruling, you could have filed an objection with the court. Did not do so. You simply refused to provide the authorizations, and now discovery is closed, and respondent doesn't have the evidence it needs for the hearing. The hearing, if they tried to admit something you didn't think was relevant, you could object then. In discovery, if they seek something you think you shouldn't have to provide, you can ask the court for a ruling, just as respondent has done, just as you have done in your attempts to get Mr. Baum removed. But you never filed anything asking that you not have to provide these items of discovery. So the items were requested. You've acknowledged that much. They were not provided. You have not, to date, asked for a ruling on relevance, but as you ask right now, I will tell you in a rule that is relevant information. It's certainly discoverable information, which again, discovery has a lower bar than a hearing for what is provided. Evidence does not have to be admissible to be discoverable. This was a proper discovery request. It was made in a timely manner. No objection was filed with this court. No protective order was sought, and it was not provided. Therefore, I also find a discovery violation with regard to the authorizations that were not signed and returned.
For clarification, so the discovery request was timely, and I responded to that discovery request with a timely objection that they filed in their request. It was, they filed all of my responses to their discovery requests in with their motion. So my objection should have been there. So I believe it would be on the record. Or the owner.
Okay, well, you did not seek any ruling from this court. You did not file a motion. You did not seek a protective order. You did not ask me for a ruling on whether or not you had to produce those items in discovery.
If I'm not mistaken, I thought the onus would fall on the opposing party when the discovery request is objected to. It's on them to file to have it overruled.
You're incorrect. They requested discovery from you. You did not provide the discovery. You did not get a protective order excusing you from providing the discovery. You simply did not decided you didn't think they were entitled to it, and you didn't provide it without asking the court to intervene. Instead, you devoted your time and significant compilation of exhibits and filings and trying to get Mr. Pham removed from the case. But you never came and asked for a ruling or a protective order against the discovery request. So the discovery request was not satisfied, and I find a discovery violation. All right, go back. So today we've addressed 5 disputes. The first is the audio recordings. We're going to have lists coming in over the next 2 days to whether there are any outstanding audio recordings that were not provided in the requested format, that is separated and in native format. Julia will file his by noon tomorrow. Pham for the respondent will file his response or his comparative list by noon on Thursday. Item 2, claimant's withdrawals from the 401k, that has been resolved. Respondent is satisfied with the email that was provided in light of the statements and stipulations today that was the full amount of the account. Regarding the employee stock ownership plan, there's no dispute that those documents have not been obtained or exchanged in discovery, and therefore they will not be admissible. Item number 3, text messages that claimant exchanged with his managers. That item has been resolved in light of the representations that those were all included in an attachment to a motion. Respondent has agreed to consider that satisfied. Item number 4, the job logs. All documents related to the job log complainant filed with the Georgia Department of Labor. I have found a discovery violation with regard to that request. Item number 5, executed authorization for complainant's personnel records and tax returns. Those were never executed, and I find a discovery violation with regard to those. As to appropriate discovery sanctions, failure to provide authorization for personnel records, tax returns, and the information regarding the job logs, I find has prejudiced respondent and prevented them from investigating and developing evidence with regard to mitigation of damages. Discovery is now closed, as we've noted. Because respondent has been prejudiced by the failure to provide discovery regarding mitigation of wage loss damages, I will strike the claim for back pay. Information regarding any work the complainant has done, any wages he has earned, all would be included within the personnel records and tax records that have not been provided or authorized for respondent to get. Without that information, a respondent cannot defend against the claim for back pay, and this court cannot meaningfully determine the extent to which damages have been mitigated to determine the appropriate amount. As for that issue, is stricken due to the discovery violation. With regard to front pay, complainant argues that he is instead seeking reinstatement, and I will allow him to make that argument at the hearing. So today I have found two discovery violations. I have imposed a discovery sanction of striking the claim for back pay for the failure to produce evidence in response to timely discovery requests that respondent was entitled to and needed to investigate mitigation of damages. I believe we have addressed all 5 issues that respondent brought. At the outset, I addressed complainant's included response requesting reconsideration of the orders disqualifying Mr. Pham.
If I may?
Yes.
I would like at least a fair chance to say a word as far as the disqualification.
Sure.
And so there's a very well, I understand that some of the issues that I've raised are slightly fringe, but there's specifically one major one that seems to be getting glossed over, and that is the Exhibit FF. Let's see here, it would be page 67, where he's filed his own, I guess, willful misdirection, if you please, or intentionally misstating the pagination on a document.
Are you citing to page 67 of your own filing?
No, this would be Attorney Pham's.
Which document are you referring to?
It is seeking discovery sanctions. So the third declaration of Attorney Pham's in support of respondent's motion to enforce the discovery order and for discovery sanctions.
Okay, and you referred to Exhibit FF, which is your deposition?
That's correct.
And what page are you referring to?
67. there's an additional page as well that wasn't filed where he says
Wasn't this the same argument you raised in your initial motion?
So it's been a reoccurring theme. Yes, it's continuing.
This specific page was raised in your first motion, correct?
This specific page, no. The emails were where I first raised it. Where hearing the Attorney Farm's associate had sent me an email saying that that the client was aware of the missing pages and working to get them to me, and then Han turns around, or Attorney Farm turns around and says that that I've received all of the pages, that there's no missing pages. That was the very first instance of filing. But if you turn to GFL Lear 29 in their actual evidence and look at the page numbering, it's not page 2 of 2, it's page 2 of 3.
Yes, this was also raised in your initial motion. I have already considered this argument, and I do not find that this creates any sort of violation that would warrant disqualification of Mr. Pham. For example, on page 58 of your initial motion to disqualify, there are emails where you're discussing the same corrective action, consists of 3 pages from 2 different page groups. This is the same issue you raised before.
It's regarding the same document, yes, but this is where he is actually intentionally identifying it. He's referring to it as page 2 of 2.
Okay, your argument is noted. I find that it does not constitute grounds to disqualify Mr. Pham. Motion for reconsideration remains denied.
All right. Well, if I may, real quick before I anticipate this is gonna be closing soon.
I'm sorry, I'm not sure what you just said. Are you asking to address something different, or this again?
No, I would like to address the authorization and the mitigation. Just a quick statement.
I've already heard your arguments on that, and I've also read your response, which was a lengthy response, as well as the consolidated list attachment you filed, which appears to be a summary of the arguments in your response. So I have heard your arguments in this regard. What else do you want to say?
So as far as I understand, as far as the cases that I've come across, that the civil procedures don't authorize a court to authorize a third party to deliver information to a litigant, specifically to a defendant's former employee. That's cited in 2 cases, EEOC versus Thorman and Wright Group, and Clark v. Vega Wholesale Inc. Both requested the exact same type of authorizations to be compelled, and both were denied in those cases. And as far as applying that to mitigation of damages, as far as I've read, the burden is on the employee to prove that that a former employee has failed to mitigate damages. Just as I can't, I can't compel them to prove my case for me. It seems it seems to be a disservice to expect me to prove their case for them. Which I know they've hired an expert to give an opinion. So which they're more, that's their, that's their choice to do. But and as far as the actual application of those documents to the mitigation of damages, the cases that I've come across, it still wouldn't apply, because mitigation of damages has to do with centers around the conditions in which that I was employed at the time. That like my previous work history and whatnot is not, it has no bearing on what jobs I would look for, or what I would be obligated to take in the future. And if I'm not mistaken, the case law even is specific in that plaintiffs have no duty to take an inferior position or an inferior job. I believe that's I've got quite a few cases here. Bill of Courts of Cemex Cement.
Mr. Lear, I read your filing. You don't need to read the filing to have anything to add to your filing.
Oh, that's just, yeah. These were not a part of the filings. That's what I was adding to, or to make part of it.
I'm just going to object to the authority that Mr. Lear is presenting that was not brief, but we are ready to address them if the court were to take them on consideration.
Yeah, any new arguments are not appropriate that weren't put in your responsive documents. And Mr. Fahn's objection is well taken on that point. As to your argument that this is not an authorization is not an appropriate item of discovery, that argument is rejected. Authorizations are an appropriate item of discovery. Respondent was entitled to ask for the authorization for your personnel records and tax returns. Regarding your argument that the burden is on employer to prove that you failed to mitigate damages and that you shouldn't have to prove their case for them, the burden is on the employer. This is why during discovery they have attempted to obtain materials, documents, items of discovery so that they can put on their case. You have obstructed and frustrated their efforts to obtain those items in discovery by refusing to sign the authorization and provide the documents. The burdens apply at the hearing. At the hearing, the respondent would attempt to prove what a respondent needs to prove. What I have ruled today, that their ability to investigate that issue and develop evidence for that issue has been obstructed by the discovery violation. So while you are not required to prove their case for them at hearing, you are required to participate in discovery. And part of your duty and your responsibilities, as mentioned several times today, that you have to answer discovery requests. You can serve discovery requests on respondent, and they serve responses to you. They can serve requests on you, and you serve responses to them. That is how adjudications work. Discovery rules allow both sides, each side, to request discoverable information from the other. The discovery rules create an obligation for each side to produce the items and to cooperate in discovery. And you didn't do that. So you're certainly correct that at the hearing, the burden would be on an employer. And to some extent, you're correct that you don't have to prove their case for them. But that does not give you the right to not provide discoverable information. You have a duty and an obligation to provide discoverable information. And because you did not do so, have been unable to do the investigation that they needed to do to litigate this issue at the hearing. And because they have been obstructed in doing their preparation for the hearing, I have stricken the issue. So your arguments are noted, but my ruling stands.
Could you make it clear for the record like the case law or where the site or cite to something that is that would over, because I didn't just outright refuse to participate in discovery. I objected just like they objected to many of my discovery requests. And
Mr. Lear, my ruling has been made on the record. This hearing is being held on the record. There will be a transcript of this matter. The ruling is of record. Wish to appeal the ruling? You may appeal the ruling. Have the ruling. Your arguments are on the record. My ruling is on the record. I find a discovery violation. I impose a sanction for that violation.
I guess it's the conclusion of law that I'm seeking.
The conclusion of law is that you violated discovery obligation.
I guess I guess I'm looking. It's the prior case law that supports the finding, though.
Mr. Lear, you have my ruling.
Neither
you have my ruling. We're done with the. I've allowed you to make the record. On this.
Hello?
Who just dropped off this call? We don't know who dropped off the call. Mr.
Yes, I'm still here.
The court reporter? Yes, Your Honor. Mr. Baum?
I'm here, Your Honor.
All right, and I'm still here. So either one of the co-counsel or my attorney advisor has dropped off the call, but they are not necessary parties, and that is, or else perhaps someone has joined. Someone new joined the call? Okay, I think we lost one of them, but that is okay. All right, I have ruled on respondent's motion. I have ruled on complainant's request for reconsideration. Complainant made other requests within his response to the motion to enforce the discovery order. Some of those seek suppression of evidence, judicial notice of certain facts. None of that will be addressed today. Those are not, A, they're not appropriately raised in a response to a different motion. B, they largely relate to hearing issues. And not to the issues in the motion. So I do not suppress anything, and I do not take judicial notice of anything, and otherwise I do not address those requests in this hearing. We'll deal with evidentiary matters at the hearing at the appropriate time, the appropriate setting. Hearing remains set to go forward at the end of May. Review your upcoming obligations. All right. So the scheduling order here of exhibits and exhibit lists with one another yesterday of this list and identification of expert witnesses yesterday. Objections to that our witness lists are due on hearing statements are due May 8th. Hearing statements a copy of your list, witness list, and of facts that are not in the of the not argument filing. Here out what will be covered in the hearing. court's copy of the exhibits are due by May 22nd. And we will convene for the hearing on the morning of May 29th for the first day, with the hearing continuing through the 30th and 31st. I also note that respondent has a motion for summary decision pending, and as noted at the outset of this hearing, complainant's time to respond is still ongoing. Runs, I believe, through this Friday.
May I?
Yes?
I also need to seek clarification on the internal investigation report. I'm not sure if I can still file a response. I know that an order was given roughly 24 hours after it was filed. So I've been working on a response to it, but I'm not sure if, like, I don't, once an order's been given, I'm not sure if I'm still allowed to submit a response to that.
You want to file a response to the report?
Well, so GFL has requested
The
to file.
report is an item of discovery that was provided to you. Discovery.
Right. I'm not that. Not that.
What is it that you want to talk to?
I'm sorry.
What is it you are wanting to respond to?
The request to file it into evidence for summary decision under seal.
So, I have our request was just whether it could be under seal. Evidence at the hearing not yet happened.
Right.
This was an evidence that has previously been subject to a protective order. Wanted to file it under, not publicly. I've granted that request.
Just for clarification.
Parties had already agreed to that document confidential. Already a protective order, and I granted the request to file the document.
And that's,
you have the document. You are not harmed in it by it being filed under seal.
I disagree. Respectfully.
So, want to file a motion argument? That's not the best use of your time, as you have a hearing coming up. Represent yourself. You're free as you see fit, within the bounds of the rules, regulations, and the law that applies to this matter. Want to oppose whether something can be filed under seal that I've already issued. The reconsideration of that order. For some reason, you believe that that document should not be filed under seal. That's the question you had. How was that?
Just if I could, yes. The order was given rather quickly. I'm not that skilled in typing.
So you have filed a number of documents that are quite lengthy. You have not displayed any difficulty typing up your documents or filing documents on your own behalf. Want to file a response or a motion for reconsideration of that order, know how to do so. Are there any other questions?
I'd just like to make it clear for the record that I don't believe any citations of any case law or anything to deny back pay in full. I don't see how that's just, but I mean, if there is, then I would love to be able to read it and bear an argument against it. But
Mr. Lear, respondent filed a motion, this exact discovery thing, alleging this exact discovery violation. You did file a response, had that opportunity, and you did do so. In fact, filed a lengthy response. I read your response. I also set the matter for hearing, heard what you had to say today. Well aware of the request for ruling, i.e. a motion, seeking a ruling that there was a discovery violation, a discovery sanction. You had ample opportunity to file a response. You did so. You filed a response. And then we addressed those arguments today, and I have given you my ruling. Response, 69 pages in length, accompanied by a second filing. You captioned as consolidated list for findings of fact. That document 16 pages in length. So you filed a great deal of material in response to the motion.
Is there no issues with when the opposing counsel files 200 plus pages?
Opposing counsel's not arguing that they weren't given a chance to make an argument, that you would like a chance to respond, and I'm pointing out that you had a chance to respond, and you did, in fact, respond.
Right, yes, correct.
So we're all on the same page. They made their motion, you made your response, I've made my ruling. That issue is resolved. I understand you disagree with it. I understand you've noted your objection to it. And that is where things are. I've made my ruling, object to the ruling.
May
For purposes of this meeting, the ruling stands.
May I ask why I wouldn't be I would imagine that generally speaking, parties would be given a chance to correct the issue. I never said that I wouldn't like sign authorization forms or provide those documents. I objected on relevancy, and I wasn't given a reason why they were relevant until the motion to enforce these the alleged discovery violations.
Mr. Lear, you've made your argument. I have pointed out that you filed no objections, filed no request for protective order. You agreed that the discovery request was timely made. You agreed that the authorizations were not provided. The discovery period, which was open for months, has now closed. Trial is in 4 weeks. The items were not provided. That is a discovery violation.
Even though
you've argued you shouldn't have to make their case for them. I've pointed out that there is a difference between making their case for them at hearing and cooperating and participating in discovery. Because you have obstructed their attempts to obtain discoverable information that prevents them and prejudices them, I imposed a discovery sanction. We have covered all of that. You have your ruling. You objected to the ruling. That is all on the record. But my ruling stands. I find that, again, as I've stated several times now, that a discovery violation occurred and that a sanction is warranted. That is the ruling.
And so just so I'm certain on moving forward. So the objections that they've raised to my discovery requests, I don't need to seek the court to overrule those before moving for the same types of sanctions.
Really, I don't know what you're referring to, and that matter is not before me. I am ruling on the motion that is in front of me. I have given you my ruling.
Right, I'm just trying to understand.
Lear, I'm speaking, have reviewed the next deadlines. Filings will come in as ordered for pre-hearing, and I will see you on May 29th for the hearing.
Ma'am, I must insist, because I still don't understand something. I still don't understand how the original objection to the discovery isn't required to be overruled before moving for sanctions. I object.
You have my ruling, Mr. You're done today. I have ruled many times. I have restated the ruling several times.
I mean,
Disagree with my ruling. I understand.
I don't disagree. I'm just trying to understand, so that way I can. I don't want to break the rules anymore. I want to be. I have not wanted to obstruct in any kind of way at any point. I gave them 30 hours of interrogation time. Freely.
Respectfully, Mr. Lear, your conduct state not back up your assertion that you have not wanted to interfere with discovery. You, as I stated earlier, took what should have been a very straightforward process and have made it very difficult. So I understand you are now unhappy with how this has played out and the fact that there are consequences for your actions. But that does not mean that you have been, as you would now like to portray yourself, totally cooperative, totally well-meaning. I reject that characterization, having reviewed the numerous filings in front of me. That is not how discovery proceeded in this case. So I understand you would now like to make your argument, but you have had ample chance to make your argument. I have heard your argument. I have ruled on your argument. Hearing is concluded. I am not going to change my rulings. I've gone over it several times. My ruling stands.
I'm not trying to.
I will see you May 29th for the hearing. You just are asking the same thing over and over, Mr. Lear. I understand you're not happy with the ruling.
No, it's not that I'm not. Yeah, I agree that I'm not happy with the ruling. But I'm trying to understand how the original objection is bypassed.
We have covered that. The ruling stands.
What?
This motion hearing is adjourned. We are
What
off the record.
was?
I will see you both on May 20th. Hearing has adjourned. We are no longer on the record. I am dismissing this call.
All right, I'd like to preserve the error for the record.
They're no longer on the record, Mr. Lear.
Okay.
I have adjourned the hearing. The hearing is over.
I have my own record. That's okay.
Thank you for your time
All
today,
parties
Your Honor.
are dismissed. Bye.
Thank you, Your Honor.